welcome to this channel. Hope you all are doing great in your life. Today we will learn a new maxim, Delegatus non potest delegare. It is a Latin maxim. If we translate each Latin word to English, then it stands like this. Delegatus means sent on a commission. Non potest means cannot. Delegare means to delegate. In short, one to whom the power is delegated, he cannot further delegate the power. So the delegated power cannot be further delegated. The concept of this very Latin maxim have its presence in the interpretation of statutes, contractual law, administrative law and constitutional law. Though the origin of this word was in Latin, but it was widely used in French in the latter half of the 15th century. In the early 16th century, the word delegate was widely used in America when an elected person was in charge to represent an area, a zone or a territory. But this Latin maxim started to put its print in the legal text in the early 15th century. The first use of this very Latin maxim can be traced in the Supreme Court of Pennsylvania in 1794. Thereafter, in the Supreme Court in US in United States versus Saf Bank, it was the first cited case. The usage of this very maxim is not limited in a particular jurisdiction. Its application can be found from the common law to the canon law jurisdiction. Application of this maxim. The maxim clarifies that the power to whom is delegated cannot be further delegated, the same without the express direction. The maxim finds its application in the constitutional law, administrative law, contractual law, agency relation and the interpretation of statute. In the interpretation of statute, subdelegation is not allowed. It is the rule of construction rather than the rule of law. The maxim is based on the separation of power. The power which is delegated to the particular organ of the government cannot pass nor overlap. In the modern governance, we get the word delegated legislation. Such delegation is not allowed or permissible unless the statute expressly speaks of it. So, in general, the further delegation is not permissible for any organ of the government. In the perspective from the administrative law, the maxim limits the excessiveness of the bureaucracy. Application in the Indian law. The application of this very maxim root to the section 190 of the Indian Contract Act 1872. The said section clarifies that the power which is delegated to the agent from the principal cannot be further delegated. Another section 192 of the said act explained that when the sub-agent is properly appointed, in such cases further delegation is valid, and in section 193, when the sub-agent is not properly appointed, in such cases such further delegation is invalid. Exceptions of this maxim. 1. Where the principal expressly or impliedly allows the further delegation. 2. Where the further delegation is customary. 3. From the conduct of the parties to the agency signifies the further delegation. And 4. Where the purpose will be frustrated if the further delegation is not allowed. Case reference. 1. A.K. Roy vs. the State of Punjab, Supreme Court, 1986. 2. State of Bihar vs. Kunj Vihari Chandra and others, Patna High Court. 3. Union of India vs. P.K. Roy and others, Supreme Court, 1967. 4. Keshav Prasad Dubey vs. State of UP and others, Allahabad High Court, 2019. 5. State of UP vs. BDP Tripathi and another, Supreme Court, 1978. 6. Nagendranath Mitra, defendant vs. Sri Sri Baldeoji Thakur, plaintiff, Calcutta High Court, 1948.